welcome to our new vlog. I know it took a while and I'm sorry for that. I hope you are still just, patiently waiting for us to give you all the information that we still promise to give you, including the one that was just referenced just now on Facebook today. We saw that and we're going to come back with all the promises that we've made, yeah? So, but first things first, we owed you a vlog that answers the questions that you were so nice to post on Typeform. So let's go through them one by one as we have always done. And I'm going to try to answer to these questions in such a way that that should help you understand better what you need to do for the written submissions. Maybe before anything else, just remember that we have extended the deadline because we know that this case, or actually both cases that you have chosen, are quite difficult. And it's already a massive challenge to ask you to solve these cases. Trust me, the value of dealing with them is absolutely, completely undeniable. And of course that this is something that you can't see right now because you're in the forest. You gotta walk out of the forest and then you're gonna be able to reflect on that. But just keep in mind that the deadline has been extended. The deadline is not gonna be on Wednesday, but it's gonna be next week, Saturday. I'm just gonna clarify it in the comment or in the description part of this video. And now let's go super quickly through the questions that you asked. Is there any possibility if you may upload a sample document regarding how we should make a structure for our written submissions? Consider it done. By the end of this video and by the end of editing this video, I'm going to also post online some examples from last year's and from the past years. And we have already spoken to some of your peer coaches who I think some of them have already shared with them their own memoranda. Of course, needless to say, this is just as an example because at the end of the day, we want you to just take that as inspiration, but also challenge yourself to take it even further. We have a page dedicated to abbreviations, but when should we use abbreviations beside the already existing ones in the case? Well, I mean, this is just, it's a very basic idea and behind this entire requirement, and I just had to deal with it myself because I'm currently, and this is one of the reasons why I've been lagging behind with some things. I'm currently doing a little bit of research for a tender that our university has won for the European Commission, for a European Commission tender on the sharing economy, if you're interested in that. And the thing is that we work as national rapporteurs. I need to report on Romanian law, and we work with exactly such a page of abbreviations. Why is that? Because when you're going to have a research project and when you're going to have 20 pages per country, at least, of information that deals with all sorts of instruments and all sorts of laws and whatnot, you might want to abbreviate them, but at the same time, you might also want to take the reader by the hand and make sure that they understand what NRCC is or what DCFR is. Of course, to go back to the question, what other abbreviations can you use? Well, if you find any legislation that is applicable, because it doesn't say in the question which case you're doing. So for instance, if this is a question that you apply to case 2, then the abbreviations are going to cover, for instance, the Polish Civil Code, PCC, the Hungarian Civil Code, HCC, etc., etc. Next, case 1. Can we assume that the circumstances in terminus have stayed the same? Yeah, well, if the case doesn't really give you any additional information, then yes, just assume that it's the same. Now we have this question that is a string of massive questions, which I think someone who would be really interested in making a novel out of this case would like to ask. I'm going to go through some of them, but I think that the answer to most of them is going to be the same. So what type of visa does Mr. Chetter Hummin have? Is Terminus part of the EU? Probably not, otherwise he didn't need a visa. Does the non-refoulement clause in the order to leave mean that the family may stay in the country as long as the civil war is going on? When did the family move to Belgium? in April 2001, when they registered in Lanaken. How old is Mr. Chetter Hummin, or Human, depending on how you want to pronounce it? What is the timeline of the conflict going on in Terminus? When did it start? When did it end? Is it already over? Is it important for the non-refoulement clause? Actually, that was a statement, the last one, not a question. Well, now, this is something that you probably see on forums of soap operas, a lot of questions to clarify a lot of things. Let me answer with one matter. If these details have not been provided in the case, it means that you can try to speculate on the basis of these details. So when it comes to the type of visa, you don't necessarily need to know that, because the non-refoulement clause is going to indeed just be linked to the existence of conflict. And then you can speculate very briefly, because you don't have the time or the space for that, very briefly, and say, just like in our good old contract law cases, well, if the conflict is of such a degree, then basically the international law obligations dealing with this matter tell us that, blah, blah, blah. So try to speculate, but where do you find these speculations? In literature. So in a nutshell, what I would suggest that you do to answer these questions is that you just search for a lot of literature and handbooks on public international law and human rights law that are going to help you understand what this particular obligation of not returning someone to a country where there is an armed conflict, what this is about and when it applies. Yeah, so just go back to this point. Then, my group has only 2 participants. We need to write only about the first 2 questions, but much is clear. But do we then still need to write a total of 12 pages or only 8? We can choose 2 jurisdictions since we answer only 2 questions. Can we talk about 3 jurisdictions to make it more interesting for us? I'm going to link this to another question that asked about the coursebook manual, because I think that what happened is the coursebook manual tells you about around 10 pages for the actual written submissions, meaning that you have 3 pages. We calculated this as 3 pages per person, and then 1 page, which is still going to be under the substantive part, but that has different or covers different matters. But I think that in person I might have shared with some of you that it's 12 pages because I just remembered it in a wrong way. So yay, you can take this in a positive way, or I guess it can also be a negative thing, that you should just contain yourself to the limits that we have mentioned in the course book. So that way we calculated, once again, let me remember, that way we calculated 3 pages per person. This is the minimum contribution that we would like you to make. Now, of course that it's nice if you write a little bit more. We're not going to hold this requirement and impose it and say, if you go 2 lines beyond this mandatory rule, we're not gonna count that in. That's not the purpose of this particular exercise. But at the same time, we also don't want you to start copy pasting articles, because God knows that you have a terrible preference for that. So don't start copy pasting articles and then making this entire space that you have been allotted to solve this case in. From 3 or 4 pages to 7 pages or something. So in a nutshell, just range between 3 and 4. So if you have 3 pages and if you're struggling to write 3 pages, write around 3 pages and that's perfect. If you're struggling to keep it within 3 pages, you can go up to 4. That's not a problem, okay? But again, go back to the purpose of the exercise and ask yourself, what is the scope of these limitations? We just want to see that you can be concise and that you can summarize a beautiful but also super difficult structure that reflects either case 1 or case 2 into a very limited space. Okay? Then, hey guys, hello. We have a question concerning the setting of the case. Namely, the case was submitted to the ECHR somewhere around 2009. Now, Belgian nationality law has been amended in 2012, 2013. Hence, we are wondering whether we are supposed to argue the case with reference to pre-2012 nationality law. Normally, when this happens and you don't need to take into account the latest developments, what you can, of course, always do, because this is a research exercise, we're not going to consider this as completely inapplicable or completely something that you should refrain from doing. Because it is a research exercise, I mean, mentioning how the law has been amended is only a plus. So again, in a nutshell, whatever you choose, whether you choose to focus on the old law or you choose to focus on or to include references to the new law, it's the same for us. And the persons who have submitted this question also added a little riddle. R plus L equals J, and then a little love icon. We have ourselves mystery. Good, next. Jurisdictions. It is stated in the course manual that it is needed to make reference to 2 additional jurisdictions. I am doing case 1, and the question now is whether ECHR law and EU law also count as the 2 additional jurisdictions. Okay, now the thing with the 2 jurisdictions that covered the DCFR, because that is comparative law. So the DCFR is based on, it's an academic exercise that is based on a lot of research made at national level. So that's where the entire 2 jurisdictions giving flesh to the DCFR comes from. However, when it comes to case 1, your comparisons, and I do believe that I mentioned this in one of the little lectures that we had dealing with the cases themselves, the comparisons are going to be between ECHR law, EU law, but also wherever it's applicable. So for instance, this would be most likely question 1, international law. So think about that, because you don't need to choose German law and Italian law as you mentioned here. And now to go back to the question that was asked earlier and that I did not cover entirely, can you choose 3 jurisdictions instead of 2? If you're doing case 2, absolutely. The more, the merrier. And here we go back to the question dealing with the length of the submissions, that it's 10 pages. However, in the second case, it states that parties should deliver a 12-page memorandum. Yes, I completely understand this point, and you are completely spot on. Like I said, make this a range, okay? And I hope that this clarifies things. Case 2, the case refers to an organ donation agreement and a contract of sale regarding the kidney. Could you please clarify, because it would change the pleadings considerably if it were a sale and not a donation. We already published a procedural order on that matter. You can find it on Eleum under course material. By answering questions 2 and 3 in the pain of love case, being the claimant, you are indirectly saying that the answer to question 1 is yes, the contract is valid. Well, that is true, Sherlock, that's great. What you will notice is that normally when you deal with arguments in such a context, so for instance, solving a case, you're going to have to base your arguments on certain presumptions. So this is one of them. And indeed, you are indirectly saying that, but what you're doing is you're saying, if you are the claimant, you're saying that even if the contract is valid, yeah? Do we need to write the memoranda in the form of the appeal to the honorary judges or in form of an academic research document? It's the latter, the academic research document. As much as my ego would love to read these kind of honorary judges format appellatives, no, make it into an academic research document, as you mentioned, and just make it objective. We spoke about this in the mini lecture that we had on how to write a memorandum. So think about your style, think about what exactly you want to emphasize, think about very concise sentences and very clear wording. Does the request for findings in substantive memoranda part mean a kind of summary of the claim? Yep, pretty much spot on. You nailed it. What is the difference between damages and compensations? Okay, that's a very tricky one. What we meant, because I think here you're talking about case 2, what we meant is damages meaning a remedy that would entail indeed some form of financial compensation. But when it comes to compensation, the way in which we have used this word has been in a broader sense, meaning that it could perhaps include restitution as well. The progression of case facts between point 18, 19, and 20 in the description of Fortress Europe. In point 19, the government states that H has a residency permit since 30 April 2009. For what then is H claiming before the labor court? If I remember correctly, it was the matter dealing with not having a legal right to work. So keep that in mind and try to go back to the original judgment and see how the judgment unfolds. Determining whether one can argue that Terminus Nationality Act Section 3.3a and b, although the descendants of neither the parents nor the grandparents is outlined in the case facts. I'm not really sure what you're trying to say, but you can use this particular piece of evidence that we have submitted specifically for one of the questions in case 1. Also in case 1, can you give us some more guidance for issue 3? The question is very broad and we do not know in which direction we have to research and argue. Thank you. Well, when it comes to case 1, issue 3 is really just about an interaction of 2 very specific fields of law, European law and human rights law. And because you have a creeping effect of human rights law in European law itself, the question is, where do we draw the line, and which court would be then the one to listen to arguments made on which of these 2 fields of law. And I think that if you want to read a little bit more about this, there is an amazing researcher who actually also at some point used to be affiliated with Maastricht University. Her name is Janneke Gerards, and she has actually written about this topic. The issues we need to address in front of the ECHR in case 1. The issues mentioned in the evidence document are issues related to European law and normally asked in front of the CJEU, but are asked in front of the ECHR. Our question is thus whether we need to address EU law substantively and extensively in front of the ECHR, or really should focus on the articles in the ECHR. We get that some EU law needs to be addressed to a certain extent, since the original case was the case of the ECJ, but still we find it difficult to address the specific issues given to us in front of the ECHR. I hope you can help us. Here the goal, and this is a beautiful question because it exactly looks at the major issue in case 1. Now, to solve this, you need to think about it like this. In front of the Court of Justice of the European Union, when the original case was decided, you had a combination of European law and human rights law. Look at what the court established and what the court ruled upon, because it will have ruled upon the main European law obligations and then considered some implications of human rights law. Now, just try to spin that around and think about the grounds that we have been providing you with when it comes to the obligations under the ECHR. Those are going to be your starting points, and finding links between those and what was decided in the original judgment is going to be the art of drawing the line that I was talking to you about earlier, of when to invoke European law and ECHR law in front of which court. Yeah? Literature really is absolutely plenty on this matter. What is the approximate date of the ECHR trial in case 1? Is it the same as its real-life counterpart? just follow the indications that we had in the excerpt that we gave you, because you don't need anything else than that. In paragraph 17 through 19, Mr. H brought an action for annulment to the Council of Asylum and Immigration Proceedings. In paragraph 19, reference is made to written observations made by the Belgian government before a court. Is this court the same as in paragraph 17? I do believe that is the case. I will double check it and indicate it in the description to this video if that's not the case, but otherwise consider that it is the case indeed. And we have, secondly, on what date does Mr. Hummin submit an application to the ECHR? I guess this is what we discussed in the first one, in the earlier question as well. Let me see, because I don't remember if we actually gave you any dates on that. Just check the description, check the description, because I'm going to indicate it there, because I will have to look into my own documents. How much does the hypothetical scenario, kids not getting Belgian nationality provided in issue 1, affect the narrative overall? For example, if we assume that the second and third of the human offspring never acquired the Belgian nationality, the family may not have been allowed to remain in Belgium for as long as 2004 to begin with, which would completely change the case overall. Or are we expected to work under the assumption that everything remains identical except for this hypothetical change? This would also bring up various logistical discrepancies, as we would have to explain some of the actions that make no sense if the children had never acquired Belgian nationality. I see this point, and you are completely spot on, because the implications and the domino effect is definitely tremendous. The one point that we wanted you to tackle in this issue is very easy, and that's a statelessness topic. So if you do not have Belgian nationality given to the first two children, what happens to the children that who were born in Belgium? Then what happens? Yeah, this is the entire point. What happens to the nationality of these children? And this way you can make use of the lecture on nationality that we have on Eleum, and that was given by Professor De Groot, but also you can make use of the additional evidence that we have posted on Eleum for this case. Are we meant to only answer the issues in the memorandum or pleadings, or can we build our arguments around it and include our other arguments relevant for the case? Well, I mean, it would be fantastic to have you expand on everything, but the reason why we have this structure of 1, 2, 3, the 3 issues for each case, is to create somewhat of a mirror image for the 2 teams that are going to go one up against the other. So just make sure that you stick to that, because otherwise it's going to be impossible to, it's going to be like having 2 parallel teams talking about completely different issues. It's going to be kind of like contemporary classical music, atonal. Hello, Miss Catalina and the rest of the skills team. Hello, we come in peace. Sorry for being so late with my question, but can I use evidence to prove a fact for case 2? Not to solve the whole case, but just to prove a fact. I just want to make it more realistic and obtain a better grade. Well, I mean, while I really endorse these goals, if you mean that you want to bring outside evidence that we never mentioned in the case, don't do that, because then this probably is going to cause a panic attack in the team that is going to go up against you. But the thing is that if it is evidence that we have provided you with and that you want to take and interpret, that's fine, yeah? But now don't invent things, okay? Let's not do that. And the last question, last but not least, hello. I would like to know if we should incorporate the issues on Eleum into our pleadings and or memorandum. Furthermore, are we accepted to go beyond these issues, or should we restrict ourselves to these issues only? So again, part of this was just answered. And then when it comes to incorporating the issues on Eleum into the pleadings, yes, so just make sure that you structure it the same way. because this, like I said, is going to really give you a nice little mirror image. One team is going to start with the issues, and then you will have the other one responding. I just got an idea, and I think perhaps this might be a nice thing, that after the submission of the memoranda, we're going to, but I should really just speak to my colleagues first about this, but it would be a lot of fun if we actually make the memoranda available to the teams that you're going to make your own memoranda available to the teams that you're going to go up against, because this way you will see also what the other teams have been doing. And there's a lot of learning points to be considered in that situation. But I think this is what we have had as questions for now. I'm going to just hurry up and edit this and post it online so that you can just bring down your panic levels. Apart from this, I think we're going to post a nice little, let me see, let's see when this would be the case. I think that we're going to try to see whether we can do another vlog, should you need one, because I can really imagine a steep panic curve that is going to probably reach its peak somewhere on Saturday. So we're gonna be here trying to support you. So I'm maybe something like a Facebook Live on Saturday, or a vlog that we can do on Saturday after you submit more questions. I'm gonna discuss this with my colleagues and then get back to you on this. But until then, I wish you best of luck, and I wish you a lot of fun and a lot of just beautiful times in dealing with what is your most likely first moot court experience. Catalina out.